Tonight, we begin with a development that immigration attorneys, legal advocates, and policy experts had feared, anticipated, and prepared for. A policy shift that unfolded not over months of deliberation, but in a matter of days. Days that have left hundreds of thousands of young people uncertain about their future. Days that have forced families to make impossible decisions. Days that have fundamentally altered what it means to be a DACA recipient in America. What the administration did this week crossed a line that legal experts had hoped would hold. And when that line broke, immigration advocates did not hesitate. They responded with urgency, clarity, and determination. Because for nearly 800,000 dreamers, this is not politics. This is their life. For months now, there had been signals, not official announcements, not formal policy memos, just signals, that the administration was preparing something unprecedented. The administration has been aggressive on immigration, yes, but they have been methodical in their aggression. Their moves have followed a certain pattern, a rhythm, almost a predictability. But what set off alarm bells among immigration attorneys this week was that the pattern changed. Legal experts who monitor immigration enforcement know the indicators. The unusual silence from DHS leadership, the internal memos that stopped circulating, the sudden reassignment of immigration judges, the unexpected budget allocations to detention facilities. All of that shifted, and whenever an administration goes quiet on immigration, it means something significant is about to happen. Immigration attorney Maria Gonzalez, who has represented DACA recipients for over 15 years, told us that her office started receiving unusual inquiries from clients 3 weeks ago. They were being called in for interviews that weren't scheduled, she said. They were receiving notices that didn't match any protocol we had seen before. That's when attorneys across the country began connecting the dots. Something was coming. And it was coming fast. Early Monday morning, immigration law offices across the country received what they described as an unprecedented policy directive, including enforcement priorities that had not been issued in over 12 years. These are the kinds of orders that administrations only deploy when they are signaling something very specific. A fundamental shift in enforcement philosophy, a rejection of prosecutorial discretion, or a direct challenge to existing legal protections. Legal observers didn't know which category this fell into, or whether it fell into all three at once. But what they did know was that the administration was changing its posture toward DACA. And when any administration shifts its enforcement posture without explanation, even by small measures, immigration attorneys pay attention. The new deportation orders specifically target what officials are calling expired DACA status holders, individuals whose renewals are pending or who have experienced any gap in their protected status. This represents a dramatic departure from previous policy. Under prior administrations, both Republican and Democratic, individuals with pending renewals were generally protected from enforcement action. That protection, as of this week, appears to be gone. The statement issued by the American Immigration Lawyers Association tonight was not normal. It was not routine. It was not symbolic. It was urgent. Attorney after attorney described the administration's move as legally questionable, administratively chaotic, and perhaps most importantly, deliberately cruel in its timing. But policy changes only achieve their intended effect if the affected community remains passive. DACA recipients did not. In fact, their response today was among the most coordinated we've seen in immigration advocacy history. Here's what we know. Within 48 hours of the directive becoming public, legal organizations had mobilized response teams in all 50 states. These weren't the standard Know Your Rights workshops. These were emergency legal clinics, resources that immigration advocates only deploy when they are preparing to fight an existential threat to their community. The National Immigration Law Center filed an emergency motion by Tuesday evening. The ACLU announced a multi-state legal strategy by Wednesday morning, and individual immigration attorneys began working around the clock to contact every affected client on their roster. Tonight, sources within immigration law firms confirmed that the new orders affect DACA recipients in several specific categories, including individuals whose renewals were delayed due to USCIS processing backlogs that had recently grown to 18 months, delays that analysts believe were intentional. The administration acted before Congress could respond. They targeted renewal applicants. They targeted those with minor administrative errors on their applications. They targeted individuals whose status had lapsed by even a single day due to processing delays. In other words, the administration targeted the most vulnerable within an already vulnerable population. The technicality that would have kept them protected. This is what made the legal community's warning so urgent. The administration's order wasn't just symbolic, it was actionable. It represented the kind of policy shift that could result in thousands of deportations if left unchallenged, and immigration advocates, understanding that fully, responded with force. Not recklessly, not impulsively, but strategically. They didn't file motions without evidence. They didn't make public statements without legal backing. They built cases on constitutional grounds. They assembled documentation of government-caused delays. Immigration attorney David Chen explained the strategy to us. We're not just fighting individual deportation orders. We're challenging the fundamental premise that the government can create a backlog, blame recipients for that backlog, and then use it as grounds for removal. And here's where the story becomes even more significant. Legal analysts now believe that the administration's latest move was designed to test the resilience of DACA protections after years of legal uncertainty. The administration wanted to see whether courts would intervene quickly, but instead, the opposite happened. Federal judges didn't delay. They issued temporary restraining orders that were so swift, so comprehensive, that even administration officials noticed. You don't get a federal court's attention that quickly by accident. But this week, immigration advocates did. Policy analysts speaking with legal publications under anonymity described the administration's shift as enforcement maximalism, a way to push the boundaries of executive authority as far as possible. But DACA recipients and their advocates proved today that they remain both legally prepared and publicly mobilized. Their filings were not only thorough, they were timed so precisely that courts had documentation before enforcement actions could begin. That timing matters because it shows something important about the immigrant rights community. It shows that DACA recipients are not passive subjects of policy. They are active participants in their own legal defense. As reports continued coming in throughout the week, we learned more about the scale of the affected population. USCIS confirmed that approximately 78,000 renewal applications are currently pending, forcing recipients into legal limbo. Immigration courts reported that 12,000 cases had been flagged for expedited review in the last 30 days alone. ICE field offices operating in sanctuary cities reportedly received new guidance prioritizing DACA-related enforcement. This wasn't just a policy memo. This wasn't just an administrative adjustment. This was a coordinated enforcement strategy. This was a fundamental shift in how the government views DACA. And that shift is the one thing immigration advocates have feared since the program's inception in 2012. For every legal victory DACA has achieved, opponents have countered with something that undermines its stability. The program has survived Supreme Court challenges, congressional inaction, and multiple administration changes. But this week's orders represent something different. They represent enforcement without the pretense of legal process. Remember, the administration thought DACA recipients would be too afraid to fight back. They thought legal organizations were underfunded and overwhelmed. They thought the courts would defer to executive authority. They thought public attention had moved on from immigration. But tonight, the exact opposite is happening. DACA recipients are organizing in record numbers. Legal organizations have received unprecedented donations in the past 72 hours. Courts are granting emergency hearings faster than anyone anticipated, and public attention has returned to immigration with intensity. What makes this moment so critical and so revealing is that the administration's latest move happened at a time when immigration policy is under enormous political pressure. Hardliners want mass deportations. Business groups want stable workforces. Educators want their students protected. Healthcare systems want their workers retained. Communities want their neighbors to stay. The administration is balancing these demands while facing legal challenges on multiple fronts. And when leaders in that position make sudden moves, they're not doing it from strength. They're doing it from pressure. They're doing it from political calculation. Immigration attorney Sandra Williams put it plainly, "This isn't about law enforcement. This is about politics. DACA recipients are being used as leverage in a larger political battle." The statement from legal organizations, now circulating widely, was designed to signal that advocates are not willing to allow quiet deportations. Attorneys said plainly that the administration's action was inconsistent with due process and fundamental fairness. That is legal language for, "This violates basic constitutional principles." You don't usually hear that tone from mainstream legal organizations unless something serious is at stake. The National Immigration Law Center called it the most significant threat to DACA since the 2017 rescission attempt. Individual attorneys described receiving more calls in 48 hours than they typically receive in a month. And legal aid organizations reported that their emergency hotlines were overwhelmed within hours of the announcement. Meanwhile, community leaders addressed DACA recipients in urgent emotional messages throughout the week. One advocate said, "You are not alone. You have never been alone, and you will not face this alone." Another said, "Your status may be uncertain, but your worth is not. Your contribution is not. Your belonging is not." And a prominent immigration attorney said, "We have fought this fight before. We have won before, and we will win again." These are not rhetorical flourishes. These are statements from a community that understands just how high the stakes have become. Here's what makes the situation even more concerning. The administration's latest move wasn't isolated. Along with the new deportation orders, several states also introduced legislation limiting DACA recipients' access to state benefits. Certain employers received guidance questioning whether they could legally employ DACA holders. Universities reported increased inquiries about students' immigration status. All of this happened within the same 2-week period. When enforcement actions move on multiple fronts at once, it means something larger is underway. It means there is coordination. It means there is strategy. And it means the response must be equally coordinated. Legal analysts are now considering several possibilities. One is that the administration is preparing to formally end DACA through executive action. Another is that the administration is attempting to force Congress into a politically difficult vote. A third possibility, the one worrying advocates the most, is that the administration is attempting to create enough chaos and fear that DACA recipients self-deport. But today, legal organizations took that option off the table. They didn't wait for courts to act. They didn't wait for Congress to intervene. They didn't wait for public opinion to shift. They mobilized immediately. What we're watching now is a test of institutions. The administration wants to see how far executive authority can extend. DACA recipients want to show that they will not be intimidated. Courts want to maintain constitutional boundaries. And Congress wants to avoid taking a definitive position. The outcome of this test will determine not just the future of DACA, but the future of immigration policy for a generation. Tonight, we've heard from immigration attorneys who are now monitoring developments hour by hour. They say court filings are proceeding faster than expected. They say community response has exceeded all projections. And they say the administration's decision to move so aggressively is likely part of a broader strategy intended to reshape immigration enforcement permanently. But DACA recipients are not retreating. In fact, DACA recipients are organizing. Their response today, swift, coordinated, and determined, sent a message to the administration that this community will fight. And it sent a message to the courts that legal intervention is both necessary and urgent. As the week goes on, we expect more details to emerge about what exactly the administration hoped to achieve. But what we do know is that the legal community's response was timely. It provided clarity to confused recipients. It provided resources to those facing enforcement, and it provided hope to a community that has lived with uncertainty for far too long. What happens next will depend on what the administration does in the next 30 days. If they escalate, this moment will be remembered as the beginning of a constitutional crisis. If they retreat, advocates have already shown they are prepared to maintain pressure. They have shown they are ready to respond. They have shown they are ready to fight. And tonight, for the first time in months, DACA recipients are no longer waiting in silence. Washington is watching. The courts are listening. And when a community refuses to be silent, it means they are demanding their voice be heard. It means they are refusing to be erased. Because this week, DACA recipients reminded America of something important. They are Americans in every way that matters. They are contributors to every community they live in, and they are not going anywhere without a fight. This story is far from over. But tonight, one thing is clear. DACA recipients will not be silent. Their advocates will not abandon them. And this nation will have to decide what kind of country it wants to be. And we will be here, covering every development as the next chapter unfolds.